Okay, are you ready? Yeah, okay. All right, everybody. I know that you have your own private conversations going on right now, but we're gonna go ahead and get started here with David McGee. He is an attorney with McGee Walls, correct?
Yes.
Yes. Okay, perfect. Yeah, he has over 35 years of litigation and transactional experience representing professionals, including real estate agents, brokers, brokerages, in the areas of professional liability, civil and commercial litigation, real estate litigation, as well as commercial and residential real estate transaction work. So basically anything about residential, real estate, commercial, real estate, anything else like that, David has it covered. He has been repeatedly named by a top lawyer by Minnesota Law and Politics and Minneapolis St. Paul Magazine. He represents clients in arbitrations, mediations, court actions, jury trials, administrative proceedings, and appeals. He also represents professionals for licensing and regulatory boards, including the Department of Commerce. All of you are familiar with the Department of Commerce. That's there are the ones that hold your real estate license. He is a very sought after lecturer at a variety of forums, including the National Association of Realtors Convention and Minnesota Real Estate Institute. So we are extremely lucky to have him here with us today. You guys are extremely lucky to be able to attend this for free. This QR code, it just pulls up his contact card information here. So at any point throughout the lecture, if you want to scan that, it's right there for you. And David, it is all yours now. Thank you so much.
Thank you. This is supposed to be the QR code for my contact information, but it was done by my son-in-law. So if something else shows up, that's not my fault, and I take responsibility for it. It works. Super. God, geez, I have to actually give him a compliment now. But in all honesty, I've been doing this for 35 years, representing real estate agents and brokerages in a variety of disputes. And I give this talk about 6 things that I think you can do to kind of lessen your coming into contact with me and having to defend you, but also to help you if you do in fact get into a case. And so I've got these 6 things, but I want you to ask any questions, raise your hands, even if it's off topic. Happy to answer any questions, and I might even get them right. So starting with number 1, and treat everybody the same. And I'm not talking fair housing. I'm talking about the way you do your business. Now, remember, you have a certain way that you do your transactions. You follow the rules that you've been laid out by your training and experience, and you do them all the same all the time, or at least you should be. Now, there's a tendency by many of us that when we're doing things for friends, somebody in your book club or somebody from church, that you're going to, kind of do it cheaper. You're going to do it differently because they're a friend of yours and there's not going to be any problems. The problem is that the moment you deviate from your structured process for anybody, you open the door for problems. And I'll give an example. I had a case where an agent was helping out a friend, didn't charge him anything. They needed some help preparing a purchase agreement. Lo and behold, the purchase agreement goes south and he gets blamed. Now, here's a guy who's just doing a friend a favor, didn't even have an agency agreement, didn't even have any compensation, but he wound up spending $40,000 to get out of a case because of that mistake he made by not doing everything he should do to protect himself. And that's the main thing. Now, I'm not sure if you movie buffs, but there's a movie, $1 Million Baby, Clint Eastwood movie. And he says, what's the number 1 rule? Always protect yourself. That's your number 1 rule. Protect yourself. Because you are nothing without that license. I mean, in terms of your profession, you lose that license, you're basically out of a job. And your ability to lose that license exponentially increases when you don't follow the rules all the time. That agent that had to pay $40,000 had his license suspended. Why? He didn't give agency, didn't give any disclosures, didn't do anything. Why? Friend of mine. I'm never going to get into trouble. Problem is, Commerce doesn't care. Commerce is going to go, did you follow the rules? The answer is no. And so he's in trouble. So number 1, treat everyone the same, which means do for them what you would do for the third-party client that just walks through the door. Always treat everybody the same, and always make sure that you're following the proper procedure all the time. And even if you're doing a friend a favor, follow the procedure. You can decide you don't want to pay him a commission. That'll be up to the brokerage, but I mean, you're probably going to probably pay the broker admin fee, but you can do that, but you still got to follow the procedure. In my world, if it's not in writing, it doesn't exist. So keeping notes, keeping records, this is number 2. Keep notes, keep records, and do confirmations. Let me give an example. I have a case right now where an agent was involved in the sale of some property and as well as the purchase of it. They were going to subdivide the property, and the subdividing included a driveway for the people that were going to buy the property and put in a home. Well, the agent had a copy of the original survey. Everybody seemed to agree with it. About 2 months later, and about a month before closing, the seller submitted what he referred to as an updated survey. Well, the agent didn't look at it. He just assumed it was an updated survey. Well, it turned out to be dramatically different than the first one. Now, what's his excuse? Well, I just assumed it was the same survey. That's not an excuse. You've got to look at these things. You've got to, everything that you get by email, you need to review. And the attachments. Do not assume that anything is just ordinary, the same, nothing like that. You've got to focus down on the fact that everything that you look at, it's kind of like a doctor that doesn't read the emergency room intake form. Okay, they can get into trouble. Things can happen, bad things. Now, we got a little bit off track there. Keep records, confirm conversations. Let's use an example. You have a client that comes in, you show them a house. They're at the house, they really like it. They see the nice backyard. And one of them says, you know what, I'm going to put a pole barn in the backyard. And, you know, I think it'd be perfect for that. You were there, you heard that conversation. What do you do with it? You just ignore it? Or what do you do with it? Now, remember, they said they wanted to put in the pole barn. Are they asking you a question? Can I do that? Or are they thinking that you're going to respond to that question by doing some research? Now, let's assume you didn't do anything. They move in, can't build a pole barn, county won't let them. Who are they going to blame? You. We told you we want to put in the pole barn. We assumed you were the professional and you would check on that. We assumed that you would follow up on that, even though you didn't say anything. So when that conversation occurs, and it doesn't have to be just about a pole barn, if somebody says something during a meeting about an improvement to the property, you need to confirm with them right then and there, do you want me to check on that? Or do you want me not to check on that? Or are you going to check on that? I'm not going to check on it, but here's the number for somebody to call. And then what are you going to do when you get back to your office or you're in your car? You're going to confirm that conversation, whether I don't care if it's text, I don't care if it's email. It just can't be smoke signals or something that I can't trace back. It's got to be something that I can pick up a piece of paper and put it in front of the 6 jurors, which are going to be the 6 people, you know, that are going to be making decisions about your life. So that I can say, no, the agent confirmed that the buyer was going to make those decisions, was going to investigate that. And sometimes the client's going to ask you to, and you're going to say, I can't because I don't know anything about it. I'm not going to do that. You're going to do it. Here's the information. You do it. But confirming that you're doing that is critical. Now, don't tell me, because nobody believes you, that, oh, my computer crashed or my phone doesn't work. I can't get my text or whatever. Nobody believes you. The 6 jurors don't believe you. They think you're hiding something. Okay, even if it's true, they think you're hiding something. Now, understand, to me, you're Snow White. There's nothing that comes out of your mouth which isn't the absolute truth. I believe you all the time. Everything you say to me, I believe, okay? But it's not up to me to make the decision. I got to convince the judge or the jury that you're correct. And the only way I can do that is with records. Don't tell me, oh, we talked about it, everybody knew. Everybody had the conversation. We all agreed, we all sang kumbaya. It doesn't work. I need something in writing confirming everything. And I know that sounds terrible. I know that sounds like one of those things where it's a waste of time. It is not. It'll save you. And keep those records. I've been doing my job for 35 years. I have all my files, 35 years of practice in a hard drive that big. Okay? Don't tell me, oh, well, I was cleaning out, I was purging the file. Remove purge from your vocabulary. There's no such thing. Everything about a case or a transaction that you're working on should be in the file. In your personal file, in your directory, I don't care where it is, do not lose it. It will save you all the time. Because like I said, if it doesn't exist in writing, it's like it doesn't exist. Because remember, there's going to be two parties competing. There's going to be your client and probably Mr. and Mrs. Client and you. Who do you think is going to win the argument about the recollection of events? They are. Number 3, go over everything every time. Authenticine has been this God-given gift for getting signatures. Okay, I understand it's convenient. It is not a replacement for not going over everything with your client every time. You need to document that I sent it to them, we went over it, and then they signed. Do not send it to them and say, call me with any questions. People don't know what they don't know. They don't know if they have questions until you go over the document with them and tell them what it is. That's the basic part of your job, is to explain the documents that these people are signing and making sure you document that you in fact went over it with them. Because what they're going to say, I'm just telling you, I got a list here. The agent went over things so fast, I did not read them. I just signed what he told me to sign. They didn't tell me to read it, but just to sign. Okay, that is the typical response that I get for that. And I'm talking about every time. So if there's an addendum that comes in, make sure you go over it with your client, even if it's a benign one, extending the closing date, whatever it is. And then if there's any questions, what do? Document those questions. Make sure you respond to their questions. You want to make sure that you document their response to their questions so that it is clear you went over the purchase agreement, you answered their questions. Because if you don't, what's going to happen is there's not going to be any proof that you went over the purchase agreement, and they're going to blame you for anything that goes awry. Let me give an example. In this case, where an agent was selling his mom's property because his mom was going into assisted living. The mom told the son that the spring before the property was listed for sale, she saw some garter snakes on the rocks in the spring next to the front door. Well, okay, this was a seller disclosure alternatives because the mom was in assisted living and they didn't think that her memory was real good. But the agent did a supplemental disclosure where he says, I'm aware that there was garter snakes outside on the rocks last spring. It was relayed to me by my mother. So then he puts that supplemental disclosure, and it was online in the MLS material. And he attached it behind the seller's disclosure alternatives. Well, this was a sought after property, multiple offers. So the agent sends the materials to the potential buyer and says, listen, we can put an offer down to the property. Here's the disclosures. Here's these things. And what do? They just go through the intent to sign and just sign the documents. Well, the supplemental disclosure is a document that they could have seen, but what do? They whipped through and signed everything. And the agent did not point out, hey, you may want to see that supplemental disclosure, especially if you're spooked about snakes. He didn't do it. People move in, and the snake problem is a lot worse than the listing agent's mother reveals. In fact, there were like 30 snakes in the downstairs, and there were snakes getting through the sliding doors. It was just a terrible, terrible situation. And in fact, we had an arbitration, and the snakes got into the tracks of the garage door opener. So when the garage door opener went up, it would kind of split the snakes in half, and there's half their bodies would be hanging there. This lady, I'll give her credit, man. She went out there to pull down the snakes, and so, but I mean, that is an example that you as an agent should point that out to your client. Yep.
Here's how you want us to document this. If we have, say we're having conversations with our clients, talking about, going over whether disclosures or whether, they have any questions. Do you want us to say, well, we had a phone call with them, or do you want us to typically write down every question and how we answered it?
Well, it would be the big topic questions, like if they say, let's use an example, you go over to the disclosure and they say they had a question regarding water in the basement. They go, it kind of smelled kind of musty. And your response would be, well, I'm not an expert. Do you want to get somebody out there to take a look? Do you want to get the inspector we hired, have them come out there and take another look at it? And so that would be where you would follow up later on and go, listen, we talked about you had some water in the basement, or you think there might be water in the basement, and we talked about things that we could do. I can contact the inspector, see if he'll come out and take a look at that issue, or we can hire somebody else. That's it. Do I think you need to summarize something like, if they wanted you to explain X and you told them, it's kind of the big things. It's kind of the things where this is going to come back and blow back on me if, in fact, there's a lack of a disclosure question, or if there's something in the document which, they had a question about and involved more than just, correcting them or explaining. Now, explain. I don't only handle snake cases, but these two snake cases are pretty interesting because it follows up on what you said. So we all know that the seller's disclosure form contains a reference to pests, and it says pest infestation. Pest infestation. So this agent is sitting down, he's about to list property, and he says, well, do you have any pest infestation? They go, well, we have some garter snakes. They kind of get through the patio door sometimes. We see some in the garage, but he asks, he goes, well, is that an infestation? They go, well, we don't think it is. So they don't X the box, but they don't make any disclosure at all. Now, that's a situation where, as an agent, you should say, listen, we talked about the fact that you had snakes, and we don't think it's an infestation, but we should disclose it. I always say this, if there's snakes, mice, bats, shrews, whatever wild animal, if that gets inside the home, disclose it. It may only be once. It may have been 20 years ago. Disclose it. It's not going to diminish unless it's more recent. Now, on that snake case, they wound up selling the property. Ms. Buyer is petrified of snakes. Little does anybody know. And she walks outside. I'm not sure if you know how snakes breed. Snakes breed in what's called a snake ball. So it's about 50 snakes. They get together and they just slither, and that's how they impregnate each other. Anyway, so she gets up, she walks outside to get the morning paper, and of course, right next to is some decorative landscaping rocks, which snakes love. And they're all going about their business right there. Well, she passes out, bangs her head, and then we got a lawsuit. Now, the lawsuit was all about what? What's an infestation? Okay, And the agent became the target because he should have said, I don't know what an infestation is, but let's disclose what you've experienced. That case would have turned out differently if they would have just disclosed the presence of those snakes. Now, we all know we don't have to disclose natural deaths and all. You know, that's something that you don't have to disclose. But just because the statute says that you don't have to disclose it, doesn't mean that you shouldn't. To give an example, this is an actual case. So, elderly man died inside his home about 2 weeks before they discovered his body. And I don't know if you know how decomposing bodies go, but they start to drain all their fluid into the floor, you know, afterwards. And so they just kind of decompose. Well, the family members came in, you know, they heard Dad died. They really didn't care about Dad when he was alive, but they certainly cared when his property was available for sale and there was to be some proceeds. And so they came a running. And so what they did is they, you know, took out the flooring on the bottom, took out the drywall, you know, painted it, did all sorts of great things. But so they sold the property. And of course, they didn't make any disclosure about the dead body. Well, who would? I don't have to disclose that. Well, buyer moves in. You know, it's the summer, temperature, humidity, and they go, what is that smell? What is that smell? And so then lo and behold, they call their agent and they say, we had this terrible smell. He goes, I don't know what it is. I'm not aware of anything. He says, well, I'll call the listing agent, see if he knows anything. Calls the listing agent. The listing agent goes, I really don't know why about the smell. Maybe it was the dead body. Okay, that's the disclosure that was eventually made. Well, we went to trial and during the trial moved for dismissal because a natural death doesn't have to be disclosed by statute. And after a while, the judge came back and made the decision. He goes, you're right, a natural death doesn't have to be disclosed, but the damage the natural death causes to the property does.
Yeah.
So it's a decomposition of the body and what had occurred. So when somebody tells you, we don't have to disclose that, think, should we? Because it might, you know, nobody, you don't want the buyer to find out about something that happened at the property after closing, and then you've got some explaining to do about why it wasn't. It's going to fall on deaf ears that, oh, the statute says we don't have to disclose it, when maybe it made sense to disclose it. Draft like you're writing for a 5-year-old to understand. This applies predominantly to amendments and addenda. And I'm not joking with you. This is actually a inspection addendum. That means where they want some work done. Here's exactly what that amendment said. All the work will be done as shown in the inspection report. That's the entirety of that. What work? When? How? Who's going to do it? Is it going to be inspected? Is it going to be evaluated? When is it going to be evaluated that it's been completed? You've got to be clear, because the person that is going to be seeing that document is not going to be parties to the transaction. It's going to be a judge and it's going to be 6 jurors. And it has to be crystal clear, what was your intent in drafting that? Just because everyone knows what you're talking about in the transaction is meaningless to the idea that you're going to have to explain that when you get in front of the jury. And you need to use the mechanism, who, what, where, when, how. That is the basics of what you make sure that your amendment or addendum says. Who, what, where, when, how. Who's going to do the work? How's it going to be done? Is it going to be inspected? Do permits going to be pulled? Is it going to be a licensed contractor, or is it going to be Cousin Eddie? Who's going to do the work? And then how is it going to be evaluated that it was done correctly? Don't tell me your final walkthrough. Please don't say, well, we went to the final walkthrough and all the work was done. If there's electrical work, your client looking at a plug isn't going to know that work got done. Okay? And don't do it on the final walkthrough. There's enough stuff going on the final walkthrough because they're all thinking about the closing. Set up a time about a week before closing so that, and inspectors will do this, to come back out and take a look and see if those conditions were taken care of. Because that's doing your job, making sure those things are taken care of that were on that list. Conversely, if you're representing the seller and the seller's doing that work, make sure that that work gets done. Hey, have you gotten it done? Send me the information so I can share it. You know, because you don't want to be the one they're pointing fingers at. Well, you never asked me for that information. You never told me that I needed to provide you the estimates. I mean, I got my neighbor next door. He did the work. Was it inspected? No. Electrical has to be inspected. Well, we just did it. Okay. You need to make sure that that work is getting done and that it's complete. Because they're going to have expected that you would do that. Number 5, stay in your lane. That means you're a real estate agent, nothing more, nothing less. You're not a contractor. You're not a surveyor. You're not an appraiser. You're not a market determiner. You don't do any of those things and don't try. The moment you say that you have those skill sets, well, I was a former contractor. Guess what? You just increased the probability of you getting sued because the assumption by the buyer is going to go, well, if you would have seen something, you would have told us about it. And you don't want to be there. So you've got to understand the most important phrase to learn. I don't know. I don't know. Okay? Doesn't mean you don't follow up with, I don't know, but I can check with the county. I don't know. I can bring the inspector out. I don't know. We can hire a contractor. That's fine, but you don't render an opinion. Anything that you say about anything about the property should come from an independent source. Okay? Well, does this property have water in the basement? According to the inspection report, it does not. Okay? Is there 30 feet of lake frontage on this property? Well, according to the county, there is. Okay? Nothing you say is just based on your knowledge. Everything you say is based upon and attributable to a document that was provided by the seller. Okay? You don't make representations. The same thing if you're representing the seller. Do not, under any circumstances, represent to somebody as if you have that knowledge. So if somebody asks you, well, does this property have water in the basement? Your answer is, according to the seller, no. According to the seller, because you don't know anything. You didn't live in the property, you don't know anything about the property, and you need to be clear about what your abilities are. Six, how many of you do arbitration? How much do you sign for arbitration when you do transactions? Anybody else? You? Okay. Why do you do it? Why do you sign for arbitration? Well, no, that's fine. I mean, that's a legitimate reason.
I've been told that it can result in a lot faster, easier for both sides of the transaction versus going to court, but that it could always, yeah.
Let me follow up with that one.
Okay.
Have you ever commenced an action against anybody in arbitration?
No.
Are you aware of a seller that's commenced an action against somebody in arbitration? It's a one-way street. It's buyers suing agents, buyers suing sellers. Okay, it's never back. So in essence, you're making it easier for somebody to sue you. That's what you're doing. You're just making it easier. Because with arbitration is designed to level the playing field. So let's assume you get into trouble, which I'm sure will never happen. But let's assume you get into trouble and a claim is made and they hire me to represent you. Okay. You'd want me to have all the tools possible to defend you and to wreak havoc upon the life of the person that had the absurdity of suing you. right? Arbitration takes all that away from me. Arbitration, basically, it's one-stop shopping. They file a claim, we go to arbitration. I don't get any of the things that I can do in a court case. I can't take depositions. I can't move to dismiss. I can't serve discovery. I can't bring pretrial motions. None of the things, all the arrows that I would have to inflict pain upon the person that had the audacity to sue you are taken away from me. Because if I had those tools, I could pound them into paste. I could make their lives a living hell because they had the temerity to sue you. But without that, I don't have those things. And basically, I am just like the buyer going to arbitration. So I always tell people they have a line on that form for you to sign for a reason. If you had to do what your client did, they wouldn't have a line there for you. They have a line there for you to sign, and you have a choice to not sign it. Therefore, what are you doing by not signing it? You're making it harder for people to sue you. Because the biggest deterrent to people in litigation, I got to hire a lawyer. And that's going to cost money. And with arbitration, pay the filing fee. They can represent themselves. Highly unlikely people would represent themselves in district court actions. So that's why I want you, which is number 6, to rethink arbitration. Is it best for you? It might be best for your client, but you have a line to fill out and you can choose not to. Now, what does that mean? It means there's no arbitration. It's not binding. There's no arbitration. Everyone's going to have to go to court. Is that a bad thing? Yeah, it may take more time, but it will protect you more. And that's what's our number one goal. Protect yourself. Protect yourself. You're not there to make it easier for your client to sue you. That's not part of the job. You're not getting that. That's not part of your education. Make myself easier to sue. No. Okay. If you represent a seller and it's a high value property, I don't know why you would ever suggest to your client, or not at least explain to him and say, you want to talk to an attorney because I'm not sure arbitration's best for you. I mean, I've handled arbitrations where it was a $3 million piece of property, okay? And the arbitrator, in that case, ordered rescission. That means the seller has to buy back the property. This was an arbitration. And there's good arbitrators and there's very, very bad arbitrators. And that's the problem. You don't know which one you're going to get, and we don't know which ones I'm going to have to confront. And remember, arbitration decisions are binding. There's no way for me to weasel out of them, no way for me to appeal it. There's no appeals. I mean, if I have a judge that makes a bonehead decision, I can appeal it to the Court of Appeals. If I have an arbitrator that makes a boneheaded decision, I have nothing. I can't appeal it. I got to live with it. And so that's why it's critically important to look at these things of how do I protect myself?
David.
Yeah. Yes.
At what point does it make sense to do arbitration?
If you represent a buyer and it's a low value property, that might be a circumstance where you might think about, doing arbitration, because you're going, it's a low value property, so the damages are not going to get too crazy. Makes it, my client is always the one going to do the suing versus being sued. But understand, even with that situation, who's the buyer going to sue? You and the seller. So just understand how easier you're making it for them. Because people go, well, they're not going to sue me. I didn't do anything wrong. Well, of course, nobody in litigation ever thinks they did anything wrong. That's the way we are. We all think we're, pure until the bad thing happens. And we're not talking so much about, in that context would be one where you consider it, but you got to look out for yourself. And so that's why I'm a blanket no arbitration. Now, there no doubt will be situations where it's going to work out that way. And just to let you know, I take all comers. I mean, you get an arbitration, I defend you. If you get district court, I defend you. It doesn't matter to me. I just want people to know that what they're giving up when they sign for arbitration, compared to all the powers that I would have if you were not in arbitration. So, any other questions on that one?
So if the buyer and the seller sign arbitration, but you as the real estate professional do not sign or you reject it, they can't sue you. Even if buyer and seller agree to arbitration, it protects you. They can still go to arbitration amongst each other, but they can't.
You can't drag you into arbitration.
Got it. Okay.
They can bring an action against you in district court, but the option of arbitration is not there any longer. So now, any questions about any of the topics of which I've covered? You guys are a quiet bunch, so I want to make sure I've covered your questions. Any topic, anywhere, anytime. Good. Then I'll leave you with one parting story, which is my loud neighbor case. My clients were selling a property up north, and their neighbors would constantly throw wild parties on the weekends. And I mean, to the point where, it was one of the reasons why they wanted to sell their lake cabin up north. So they go ahead and sell it, but on the disclosure form, it doesn't say anything about wild parties next door. It doesn't say anything at all. So of course they don't say anything. And so of course they sell it, and the buyer moves in, and all of a sudden they're awakened at 3 o'clock in the morning because wild parties next door. And the seller says, well, it's nothing to do with the property. Well, it does deal with the property. It's my enjoyment of the property is being diminished. And they go, well, we've never been able to sell the property, because of those conditions, because, we wouldn't want to buy it. So I explained to them, I go, well, here's the difference. You had a problem, and you had a difficult problem, one that probably couldn't be solved, okay, other than calling the police and doing all sorts of things. But you decided to pass that problem on to some unsuspecting buyers that would not know unless they're at the property at 3 o'clock in the morning and they hear the wild party. So in essence, what you did is you passed on that problem to somebody else. And so when you're listing property or representing buyers in looking at properties, ask those questions. I mean, ask the odd question. Like one that's not on the disclosure form but happens all the time is, people smoked in the property? Okay, that's not on the disclosure form. And people can buy equipment at the time of the showings that would dissipate the smell of smoke. Just because it's not on the form doesn't mean you can't ask. Ask the questions, especially if your client is somebody that this might impact. Okay, whether that's questions about what the use of the property is, what can happen, what do they plan on doing with the property. Like if they say, well, we want to build a pole barn, I always said, make sure you confirm that. But you can ask the listing agent, say, listen, my clients are thinking about a pole barn. Are you aware of any issues with that? Because he'll be duty bound to say that his client actually made a petition when he owned the property that he wanted to get a pole barn and was denied. That'd be good information for you guys to have. So don't be afraid to ask those questions, especially if those questions are important to your client or you think they might be. Doesn't mean you have to ask all the questions in the world. Doesn't mean you have to send them a 50-page questionnaire. You just, on those something, don't be afraid. There's no rule that says you can't do that. Too many agents think, well, if it's not on the disclosure form, I don't want to know about it. No, if you're representing the buyer, you do want to know about it. So make sure you ask those uncomfortable questions. So, okay, guys, absent any questions, I will let you go, and thank you very much for your time. Oh, sorry, question.
Were there any statute of limitations on some of this information you went over?
The statute of limitations is 6 years.
Okay.
And so that runs from the discovery of and whether it's misrepresentation or fraud, under the Arbitration Act, there's a 2-year limitation period that is, the exception has swallowed the rule, meaning it's practically not enforceable at all. If there's any fraud, they're going to toll that statute of limitations. So short answer is that there's a long period of time for people to bring cases, and there's really the finish line is far off into the distance. Now, practically speaking, if somebody's going to bring a lawsuit, they're going to bring it soon, within the first or second year. As more time passes, those things dissipate quite a bit, except sometimes you get a case that'll spring out of nowhere, but most of the time it does not. So first 2 years, if it doesn't bring up, you probably can take a sigh of relief and go, dodge that bullet. So one last thing on the Department of Commerce. If you ever get a phone call from the Department of Commerce, basically say, take down their number and say you're going to call them back. They record all phone calls. So if they get you on the phone about a transaction of which you cannot remember anything about because it happened so long ago, and you start guessing, well, they're going to use those guesses against you because they're recording your phone calls. And you should always run to your broker and make sure your broker's aware, and then so you can learn about what that transaction is and be better educated to answer their questions. So Commerce is not your friend. Commerce is there. If they're calling you, they already think that you've done something wrong. So with that upbeat note, thank you very much.
Awesome. Thank you. Once again, David's contact information is on the QR code, so make sure that you scan it if you have any questions, and you guys are all set.
Thank you.
Thank you very much.
You're welcome.
I had no idea about that.
What?
I had no idea about arbitration.
Oh, yeah.
I signed it because sounds easier.
Yeah.
On the surface, it does.
Oh, yeah, it's easier.
Oh, we're just gonna have two people talking about it.
Yes, they were.
I kind of know what it is. It's like, don't go to the.
Yeah.
There's no doubt.